All right, good morning, everyone, and welcome to our second episode this season of Space Law webinars at the Law, Technology, and Warfare Research Cell at the U.S. Air Force Academy. I'm Major Matt Ormsbee, and I'm pleased to bring you another webinar on space law. For our second webinar, we're very excited today to welcome Dr. Eytan Tepper. He's a visiting assistant professor and the director of the Space Governance Lab at Indiana University in Bloomington. He's also affiliated with the Ostrom Workshop, established by Nobel laureate Elinor Ostrom, and he teaches space cyber governance at the Maurer School of Law at Indiana University and space governance at the Hamilton Lugar School of Global and International Studies. He's also the program director for Indiana University's new Space Cyber Security Certificate program. After earning his doctorate degree in air and space law at McGill University, he subsequently pursued a postdoctoral fellowship at the NYU School of Law. His approach is transdisciplinary, and he leads several projects funded by grant agencies in the US and in Canada. Dr. Tepper has published extensively on space law and governance. That's the topic of his talk today. And you can find more of his research in the Maryland Law Review, the NYU Journal of International Law and Politics, the Journal of Space Law, Space Policy Journal, and New Space. Finally, he has 2 book contracts with Cambridge University and Springer. And finally, prior to returning to academia, he was a practicing lawyer with a career spanning the public and the private sectors, representing government ministries in Fortune 500 companies. Before I hand things over, Dr. Tepper has graciously said that if questions should arise during the webinar, during his talk, we can pose them immediately instead of waiting until the very end, or if that's your preference, you can wait till the very end of his presentation. Dr. Tepper, thanks so much for being with us this morning. At this time, I will turn things over to you and let you begin sharing your slides to begin your presentation.
Thank you. Hello, everyone. Thanks for the introduction. I'm happy to be here and share with you the results of my research and the way I see and I think about the laws of space warfare. It's something that I've been working on for quite a while, and it is going to be published soon. Let me share with you my slides. Can you see them?
Yes, we can.
Okay, good. So the topic of my talk today is the laws of space warfare, a tale of non-binding international agreements. The full version of it will be published as soon as it is now in editing. It will be published in the Maryland Law Review. And this is kind of you can see here also the outline of my talk. First, I will talk about the international law applicable to outer space and to space warfare, which is maybe going to be the shortest part of my talk because there is not much of it. And then I will raise the question, what about peaceful purposes? How come we're talking about the laws of space warfare or even space warfare when there was so much talk about space being for peaceful purposes only? And then we'll go back to see the general trends that happened in international law, or what I call the softening of international law, the Big Bang of space governance, and this will all lead up to the various non-binding international agreements on space warfare. This is, as I say, the present and the future of the regulation of space warfare. First, a few words about, I'm at Indiana University, Bloomington, as I mentioned. I established in 2022 the Space Governance Lab. We have a few courses with the law school, with the School of Global and International Studies, and even with the Kelley School of Business. We have several research projects including on space and cyber security, which is something that is taking more of our attention and time. We do have working groups that meet occasionally. If you go to the website, you can join our mailing list. We don't spam, we send once a month at most. And you're invited to keep in touch if you're interested to join a working group or to be in touch with a research project. So space it's a question, but I think that the answer is pretty clear. Is the space going to be the next frontier for war? So there is a nice there are a couple of nice YouTube videos that you can watch on that, and this is a quote from Dolman, who is an expert on military strategy. And he said, and this was a few years back, he said that the coming war with China will be fought for control of outer space. Although its effect will be widely felt, the conflict itself will not be visible to those looking up into the sky. It will not be televised. Most will not even be aware of it is occurring. It may already have begun. We know that space has been used, or we know that the space assets have been used in the past to support operations in other domains, in land, sea, and air. You might know that the first Gulf War in 1991 was called the first space war. During the war in Ukraine, we saw for the first time a targeting of space assets as part of a military campaign. So this is another level of outer space being used for military purposes. It's not just to assist operations in other domains. Now space assets are a target. Specifically, they were targeted by cyber attacks. The most famous one was just on the eve of the Russian invasion of Ukraine. They launched a cyber attack on the services of Viasat, which is an American commercial space company that provides services to many countries in Europe, but also to the Ukrainian government and military. This is the course. So that was a new level of space being part of warfare, and I can talk a lot about space and cyber security. We even have a new program on that. It is becoming, as I see it, the main mode of the space warfare for various reasons. But let me go back and talk about the laws of the space warfare. So we might even start before the beginning. Does international law apply in outer space? That was a legitimate question. International law was made by humans on Earth, and who's to say that it applies to outer space? But then came the Outer Space Treaty and gave us a rule. So Article 3 of the Outer Space Treaty says that that the states shall carry on activities in the exploration and use of outer space in accordance with international law. This led many scholars to say that international law applies in outer space. I wouldn't go as far as that. I think there is a different, that this is too strong a statement than what the article says. I see Article 3 as something like an extraterritorial application of the law. It doesn't say international law applies in outer space. It says that it applies to activity of the state parties to this treaty. So every state who signed the Outer Space Treaty, when it conducts activities in outer space, there is like an extraterritorial application of international law. If a state did not sign this treaty, it might say that international law does not apply for its activities in outer space. I think by now this rule became customary in international law, so it will apply to activities of all countries. But again, it's extraterritorial, and one case that might be an exception if there are aliens in outer space, they will not be bound, or they are not bound by international law because it applies only to states. So that was the first step was to apply international law to the extent that Article 3 did, and then once you applied international law to what states are doing in outer space, of course you apply a very extensive body of laws that includes also the laws of war. The laws of war, you probably know, is the segment of public international law governing all aspects of international armed conflicts. It has two subcategories, use ad bellum and use in bello. The first one is everything that happens until a war breaks, and the second one applies when there is a war. So use ad bello talks about when is it lawful for a state to resume to the use of armed force. In general, as you know, the UN Charter prohibits the use of force, but it also has an exception in the case of self-defense. So all this happens until you have a war. Once you already have a war, then you have the use in bello, or the law of armed conflict, also known as international humanitarian law. These are rules that regulate behavior during an armed conflict. Key documents in this context are the UN Charter of 1945, the Hague Conventions on opening, which talk about opening of hostilities, methods, and means of war, the 4 Geneva Conventions, and the additional protocols. Of course, you have also customary international law and ICJ decisions. The distinction between use ad bello and use in bello is also relevant to outer space. In recent discussions of the open-ended working group on space security, which I will talk about later, some of the delegations raised the issue of the application of international humanitarian law to outer space. China was kind of against a discussion about that. Their argument was that since war in space is prohibited, then we don't need to talk about international humanitarian law because it only applies when there is war. This is just to say that these distinctions and all these rules are relevant also in outer space. So by this like one sentence in the Outer Space Treaty, we have important this very extensive body of laws. I will not elaborate on those general international law because I want to focus more on things that are specific to space warfare. And when we talk about space warfare, we always start with the Outer Space Treaty. So the Outer Space Treaty, you might know, is a treaty from 1967. There are more than 120 states that ratified this treaty. It is widely accepted as the baseline for activities in outer space. Of course, all spacefaring nations are party to this treaty. So this is the baseline that is agreed upon all. It is quite vague and general, like a constitution. I see it as the constitution of space because it is accepted by everyone. It does touch the main point and provide general norms, but it is not specific, and there is always debate on its interpretation. The Outer Space Treaty includes one article about military uses of outer space. This is Article 4. And what it does, the first, and there are two paragraphs. The first is dedicated to weapons of mass destruction. And for this, we see a total ban. You cannot place in orbit around Earth any object carrying nuclear weapons or any kinds of weapon of mass destruction. So weapon on mass destruction, not in orbit. You cannot install weapons of mass destruction on celestial bodies or in outer space in any other manner. So total ban on weapons of mass destruction in outer space, which also means that there is not a total ban of any weapons in outer space. From what is written, we can conclude what is not prohibited. It doesn't say just weapons, so there is no total ban of conventional weapons. Then the second paragraph says that the moon and other celestial bodies shall be used by all states parties exclusively for peaceful purposes. And I want to emphasize the word exclusively, meaning it's not also for peaceful purposes and for military purposes, only for peaceful purposes. And there is prohibition on establishing military bases, conducting maneuvers, and so forth. So this is another wide ban, but this applies only to the moon and other celestial bodies. So what we can understand from this article, you cannot place weapons of mass destruction anywhere in outer space. Celestial bodies are exclusively for peaceful purposes. What is left is Earth orbit and void space and conventional weapons. So what we don't see here is a prohibition on placing conventional weapons in orbit around Earth or elsewhere in void space. And this is the main article that we have, the main legally binding treaty that we have about space warfare. The other thing that we have that is a legally binding treaty is the treaty, the test ban treaty. It's a treaty from 1963. It was the first treaty to explicitly refer to outer space and to space warfare. It prohibits nuclear weapons test. You can see the image below. This beautiful picture is from a nuclear test that the US did It's very beautiful, but probably also very harmful. So this treaty prohibits that. It is very widely endorsed. Although two main nuclear powers, China and France, did not join this treaty, that this treaty is a success, meaning that no nuclear test has been conducted ever since. There is another multilateral regime that is also relevant. I will not talk too much about it, but there is the Missile Technology Control Regime, which I'm pretty sure China is not part of it. But this regime limits the distribution of missiles and missile technology, so you cannot sell those to any country. There are limitations here. And basically, rocket launchers are missiles. So when you launch a satellite, you use a rocket launcher that is basically a missile. So if you cannot share missile technology, you cannot share launch technology. So there is also limitation on the sharing of technology of rocket launchers and rocket launchers technology, because they can basically use as missiles. If this talk was only about the legally binding rules dedicated to space warfare, I would stop here. But there is more. But before we get to that, let's also talk about which are the forums that all the discussions about space warfare are made. So you have, of course, the UN General Assembly and the Security Council, and then you have organs that are more dedicated to security issue. You have the UN First Committee on Disarmament and International Security, and the Conference on Disarmament is kind of works for these treaties. And then you have the UN Institute for Disarmament Research, UNIDIR. It's a research institute, and the UN Office for Disarmament Affairs, which is more of a secretariat, and you have the tribunals. There are a few more organs. They are more oriented to civilian uses, but there are issues that are borderline. So you have the UN Committee on the Peaceful Uses of Outer Space, and the UN Office of Space Affairs, and the ITU. So COPUOS is talking about peaceful uses, but for example, when there were discussions, when they were trying to talk in the group of security about space debris or about ASAT missiles causing space debris, some countries says, well, space debris is a topic for COPUOS. Before I go on with talking about space warfare, I want to do a short break and go backwards. How come we are talking about space warfare when it was supposed to be peaceful purposes? So if we go back to the beginning, the first UN resolution about outer space from 1958, so just a year after the launch of Sputnik 1, in the preamble it says, recognizing that outer space should be used for peaceful purposes only, and also wishing to avoid the extension of present national rivalries into this new field. And even in the outer space, in Article 3, when it talks about the application of international law, it talks about that states parties shall carry on their space activities in the interest of maintaining international peace and security. If all this is the case, how come we are even talking about space warfare? one thing is to, so one thing is that 1958 resolution was a UN General Assembly resolution, which is not legally binding, and the Outer Space Treaty is legally binding. So we go by the Outer Space Treaty, and as we saw, Article 4 does limit military uses of outer space, but does not preclude all of them. It does not ban conventional weapons, and what is exclusively for peaceful purposes is only celestial bodies. But there is even more than that. Even there is a question on the interpretation of what is peaceful. So one interpretation is to say that if we talk about peaceful uses, then it means that any military use is forbidden. But then there is another interpretation promoted by the US that peaceful means that offensive use is forbidden, but defensive use is allowed. So the position of the US and many other countries agree, not all, but many other countries agree that peaceful uses meaning non-aggressive. If we take this interpretation, even on celestial bodies, which are supposed to be exclusively for peaceful purposes, you can still do non-aggressive or defensive military uses. In this context, Bing Cheng, which is or was one of the leading experts on space law, international in general, but also specifically on space law, he noted that there is no ground for the US interpretation. But he also notes that other commentators who saw the ban as too much, it doesn't also prescribe to that. All this to say that the outer space, the peaceful is to a certain extent, only to some places, and arguably only for non-aggressive, which does leave enough space for military uses of outer space. And here we come to talk about international lawmaking in the 21st century, the big bang of space governance, and how it comes into play when we are talking about the laws of space warfare. So let's start with what happened before. So international law is the body of legal rules, norms, and the standards that apply between sovereign states, other entities that are legally recognized as international actors. Key milestones is Hugo Grotius' seminal Mare Liberum, the start of international law, the Peace of Westphalia treaties, UN. These are just some key milestones. But the thing is that traditional international lawmaking was legally binding treaties. This is how we saw international law at the beginning, and treaties that were done there. We have whether it is the Peace of Westphalia or the Hague treaties or that, and of course the UN Charter. At the beginning, it was international law is being made by legally binding treaties. These are the main source of international law. But this has changed in the 21st century. So we can see here there are a couple of two interesting articles to check in this context. One is an article by Harold Cole, which is an international law professor at Harvard Law School, And at the time, he was the legal advisor for the Department of State under Hillary Clinton. And he wrote it after his experience. And he even said that considering the experience that I had now, I think that we need to teach international law in a different way, because international law now is not just a legally binding treaty or Westphalia top-down treaty making. Rather, it is a dynamic interaction of private and public actors in a variety of fora to generate norms. And he shared his experience that most of the instruments that they were making were not legally binding treaties, were under many other names, but not legally binding treaties, not even executive agreements signed by the White House. And then just this year, there is an article by Bradley Goldsmith and Hathaway. They went on and did also an empirical study, and their conclusion was that non-binding international agreements are increasingly dominant in the practice of the US and around the world, with profound implications for the future of the international legal system. There are other writings about it. This literature from international law kind of, I don't know if it was inspired, but it comes kind of after similar literature or with from international relations. So international relations scholars, starting in the early 2000, also talks about the changing dynamics of international regulation. International relations are more looking, it's political science, so they are from the social sciences. They are looking at how things work in practice. So it is similar but different from international law, and they observed similar phenomena. We can also see it generally in outer space law. We have 5 space law treaties. The first one is from 1967. The last one is from 1979. From 1979 until now, there was no any new treaty about outer space, and none is expected in the foreseeable future. So also here we see that. Why is international law softening, as I call it? There are reasons of global politics and domestic politics. In the global politics context, we see an increase in the number of states. When the UN was established, it was something like 50 countries. Now we have 193 countries. Of course, it is harder to reach an agreement. There is more voice for developing countries. There is diffusion of power. The BRICS, well, the BRICS also include Russia, but China, that was for decades almost absent from the global arena, is of course now very dominant. Also other countries that have risen, India, Brazil, and South Africa. So there is more diffusion of power. There is even multilateralism in general is increasingly contested, and there is a continued split between East and West and North and South. But there are also reasons of domestic politics. There are internal divisions in countries. So it is in the US, the legally binding treaties need to go by the Congress. The more there is division, it is harder to approve such treaties. And also there is more bureaucracy. So if you need to have an international agreement now compared to 40 years ago, internal bureaucracy, not just in the US, in other countries, is so long and daunting that officials will opt for something that is quicker, even if it's not legally binding. And this is what I called somewhere else as the Big Bang of space governance. It's an article that I published last year with the NYU Journal of International Law and Politics. The argument there was basically that since international lawmaking or legally binding treaties have stopped since '79, but the field still develops and we need more rules. There is undersupply of rules. It leads to decentralized lawmaking. You see all sorts of forums popping up, discussing a certain topic and putting forward norms or rules. Most of them are not legally binding. How much time do I have until 11:50?
Yes, sir, that's correct.
Okay, so so now I get how all this comes to play when we are talking about space warfare. So generally there is the notion of multi-track diplomacy, which means that there is track one, the official of the governments, there is a track 1.5, government and non-government, and track 2, non-official. We see that also coming into play generally when we talk about space warfare. But in other fields of space, in other issues of space law, you see more non-UN related forums. When we talk about space warfare, most of the forums are still I see a question. With the trend towards non-binding instruments in space, what, if any, impact do you believe this will have on use cogents as a source of international law? That's a good question. I mean, one might say, so one might say that non-binding, all these instruments that are not treaty, maybe at a certain point will become a customary international law, which is possible, but there is a problem with that. Customary international law arises when you see when we see custom behavior of many countries, but it has two conditions. One, you need to see that enough countries are acting in a certain way to say that it's a custom. But the other condition is opinion jury, means that those countries act this way because they think there is a legal obligation to do so. And this is a problem, because if you have a non-legally binding instrument that was meant to be non-legally binding, you might later say that, yes, countries are acting in this way, but not because they think there is a legally binding duty. Rather, they think it's a more responsible behavior. So I'm not sure if it will be part of use cogents, Maybe later, when there will be rules, they will be compiled to a treaty somewhere in the future. If I go back, when we talk about space warfare, most of the discussions are off UN, but still UN related bodies. So there is work on the UN from around 1980 on PAROS. This is how they refer to it, prevention on an arms race in outer space. There's also work on TCBM, transparency and confidence building measures, and there were reports on that, but these are not legally binding. There was a proposal for a treaty that China and Russia put forward, which failed twice. It's a treaty on prevention of the placement of weapons in outer space and of the threats or the use of force in outer space. So again, legally binding treaty failed. What we do have, we have a resolution that was initiated by Russia on no force placement of weapons in outer space. We had a separate process that the EU tried to push forward the international code of conduct for outer space activities. It was security related, but this failed. I will maybe go back to that in a moment. But so here you have, I will not elaborate on that, but there is the transparency and the confidence building measure. This is what I want to spend a couple of minutes about. This is a process that started, there was a UN resolution at the end of 2020, if I believe, to establish an open-ended working group. So it's an off-UN forum. It started with a UN resolution, but it's a process of UN. Countries meet. They met in 22. The last meeting was in August. The purpose was to try to reduce space rates through norms, rules, and principles of responsible behavior. There were discussions there. I mean, there were more than 60 countries that participated, and also non-state. The discussions there were very comprehensive on many topics, but it ending up not even adopting a report, or they couldn't agree on any rules or norms, but more than that, they couldn't even agree on kind of a summary of what was discussed. And the line of divisions today are still those that actually were at the early 80s. Russia and China want to ban weapons that are placed in outer space, in orbit around Earth, and in outer space in general. The US at that time wanted to ban anti-satellite missiles. That was the different in 1980. This is still the different now. The proposed treaty by Russia and China talks about space weapons, and the US also just a year ago pushed also in that group, but also promoted a pledge of ASAT test ban, banning the test of anti-satellite missiles. So you have those two ends trying to push different agenda. And the reason is that the US does have superior capabilities in outer space. So this is why Russia and China would like a prohibition on space weapons, because they are afraid from US superiority that they will not be able to keep up with. On the other hand, and for this reason, because they are afraid that they will not keep up, they have developed anti-satellite weapons that allow them a bit to level the playground. And this is why the US is against those missiles. So the same debate from the early 80s we see now. The other line of division is between Western countries who are pushing for non-legally binding norms. And the ASAT test pledge is a political one-sided pledge. It's not legally binding, but more so the open-ended working group is a process that was supposed to lead not to a legally binding treaty, but rather for rules and principles of responsible behavior, meaning not legally binding. But Russia and China and actually most countries that are not Western countries do prefer legally binding norms. And this is part of the reasons that that this work failed, because they did not want to support such a process. But this is not the end. There will be another work, I think maybe next year, of a group of governmental experts. Again, it's like off-UN working group of 25 diplomats under closed door that hopefully will introduce some report, not a treaty, but it will be a report that maybe will have some norms. There will be another open-ended working group after that. But generally, what we see is that trying to adopt legally binding rules does not work. The only foreseeable way forward is to incrementally adopt norms or other rules that maybe now are not legally binding, but maybe somewhere in the future will be incorporated to a treaty, or maybe even will become use cogents. One of the, and I will just say a few words, there are the manuals. So we had previously the San Remo manual on the armed conflict at the sea. There is the Harvard manual on air and missile software. And for space warfare, we have the MILIMOS, with the McGill manual on international law applicable to military uses of outer space. And this is probably the most comprehensive document that we have about the military uses of outer space. This is not a legally binding document. This manual, like other manuals, is the work of an international group of experts. Of course, not just from the West. In the MILIMOS, you had participants from Russia, from China, from India, from European countries, from Africa, so from all over. So it represents a perspective from all over. It is mostly by consensus. It is not legally binding because it's not an international treaty, but it does not introduce new norms. Rather, it looks at the existing international law, and what it says how does this law applies to outer space and how to interpret it in the context of outer space. And the idea behind this and other manuals is that at a certain day, when the legal advisor of a military will have a question, can we or cannot we do this action, this Milamos, this manual will be kind of a first reference, because this is a very comprehensive work that and the most elaborated one on this. And also, if you work according to the Milamos, you have much less chances of getting international rebuke of your actions. So the hope is that a country that will want to not to be a rogue country, but to work according to international law, and that want to maintain its reputation, will more or less follow the Milamos. You have here kind of a list of all sorts of like small forums. There sometimes there are even ISO standards, or you see different forums with different names, adopting different names of documents, but all of this is done not as legally binding treaties. And I want to stop here. And take your questions.
All right. Thank you, Dr. Tepper, for your research presentation and your thoughts on this important topic. You raised many important, interesting points about space law and governance for all of us to think about. So yes, we have some questions from participants at this time, and by all means, anyone else can add questions as we go through these questions as well, if you've been holding on to your question all this time. One participant asked, with the trend towards non-binding instruments in space, what, if any, impact do you believe this will have on use Kogan's as a source of international law?
So I kind of refer to it that use Kogan's is more like, it's like the customary international law. And for this, you need to see state practice. And this is something that we might see, because even when countries take non-legally binding commitments or political commitments, they do have an intent to follow that. Otherwise, they wouldn't even take it, even the political commitment. So we might see state practice, but there will be a problem with opiniori, meaning the second thing that you need to show for use Kogan's, that states acted so because they saw there is a legal duty to do so. This will be harder to prove. So how it will affect use Kogan's, I cannot tell. I doubt that there will be effect at the beginning. I think these rules will need to be more established and maybe incorporated in a treaty or some documents that are higher up in the spectrum of being legally binding.
Thank you, sir. Another participant had a related question, which is whether you believe that the non-appropriation principle from Article 2 of the OST, or sort of free access to areas in outer space, if that would also fall under use Kogan's, in your opinion, if you have any thoughts on that?
Yes, I think it is. Traditionally, customary international law would take a long time to form. You would need to see maybe decades of a state practice. But and this is something that kind of started with outer space law. There were talks about instant customary international law, meaning customary international law that like happens really fast. And I think that we can see that in outer space law, and like in some basic rules of the Outer Space Treaty. And I think that the non-appropriation and the free access is part of them. I don't think that I never heard any country or anyone denying or objecting to this. So I do think that by now this is use Kogan's.
Thank you, sir. And I believe the last question we have is concerning the Artemis Accords as one of the most prominent non-binding agreements out there. We have new states signing somewhat routinely. I think Germany signed in just the last week or so. Do you believe that Artemis and similar agreements will continue to gather steam and form like non-binding norms that may eventually become customary international law?
Yes, the Artemis Accord is a very interesting case, and the number of countries that are signing is growing. It is something that was prepared by the US, but so NASA, its flagship program is the Artemis program, to go back to the moon and to establish a self-sustained habitat on the moon, which means it is going to be something long-term. And this is a project that is open for international partners. But if you want to be part of the Artemis program, if you want to go to the moon, you need to sign the Artemis Accords. This is how the US puts it. Most countries cannot go to the moon. It's so expensive and complicated that only the US, Russia, China can do it. So for all other countries, if you want to go to the moon, your only way is to partner with any of those. And if you want to partner with the US that has the most advanced program, you need to go by the Artemis Accord. So the Artemis, so we will see more countries, and even countries that at the beginning didn't like the Artemis Accord joined. And the Artemis Accord is a framework, and it is intended to be as a framework, and it will produce more specific agreements, for example, on safety zones, and for example, on the use of mineral resources. And because the Artemis Accord is led by the US, and because the US prefers non-binding agreements, I'm pretty sure that all those agreements will either be non-binding, or if they will be binding, it's only because the US has an interest for a certain binding agreement. So we will see this trend also in the context of the Artemis Accords and with what I call the Artemis bloc, because China and Russia, of course, are not part of it.
Yes, sir. Well, thank you. Seeing that we have no other questions and that we're just about at the top of the hour, we'll wrap up for the day. Dr. Tepper, we want to sincerely thank you for your time, for your research, your presentation today, answering all of our questions. I also want to thank all of you, our viewers and listeners, for your attendance. We have many more exciting speakers lined up for the academic year, so please keep tuning in to our Space Law webinar. And at this time, I'll wish everyone a great day, and thank you again for tuning in.
Thank you, everyone. Thank you.